Well, why don't we start all the way down there? Why don't you, if you guys could introduce yourself and kind of what you do, but also just in general, your sense, your feelings about candor and kind of where it is and what it means, and then we'll work down here. And then I have a bunch of very specific questions for you guys related to the practical approach to some of these events and cases, particularly from your perspective.
Sure. Good afternoon, everyone. I'm Stacy Coder. I'm a lawyer practicing at the Finley Law Firm here in Des Moines. I have the pleasure of representing a variety of medical professionals throughout the state of Iowa, individuals as well as medical institutions, hospitals, and the like, in connection with malpractice defense work, as well as compliance and regulatory matters, administrative issues, board matters, et cetera. Thanks for inviting us here today. I'm very interested in this topic. I've been following it for years as the legislation was developing and ultimately was enacted, and now it has been around, I guess, long enough to even be amended a bit in this last session. So it's a topic of interest to me, and I'm looking forward to our discussion here today.
Hello, my name's Connie Alt. I'm a lawyer in Cedar Rapids at Shuttleworth and Ingersoll, where I've practiced about 33 years. And I do a lot of medical malpractice defense as well as hospital and medical variety of healthcare type work. I think I'm here, as is Karen, because we have been introduced to candor law through Dr. McCoy and the folks at Great River Medical Center. I've represented them for a number of years and have had the pleasure of helping them with some of the cases that they've been doing candor discussions where an attorney is involved. I don't typically get involved when there are cases that they take to candor are pro se or don't require an attorney, or an attorney isn't involved on the other side. But when there has been, I've been involved, and it's been fascinating. I think we've all had clients who have done some sort of candor type, not in the sense of our statute, but sort of I'm sorry type work, and I'm sure Stacy has over the years, where we tell patients, and we've always counseling our clients, that one of the things we see in litigation quite often is that the litigation gets filed because of a desire to know more or request for information that the patient feels that they've been denied. And so I'm always interested in ways to avoid those kind of cases going into litigation, and I think candor's a real great process to avoid that, and hopefully we can share some insights about some of the cases we've worked on and how it's worked for us.
I'm Karen Lorenzen. My firm is Hayes Lorenzen Lawyers in Iowa City. I'm the sole plaintiff representative. Do a lot of PI, a lot of medical malpractice, have for the last 20 years with my law partner, Jim Hayes. I don't know of another plaintiff's firm, actually, in the state that has worked on candor cases. As Connie indicated, we've done 4, with a 5th scheduled, with Great River. And from the plaintiff's perspective, I think it's an opportunity for your clients to know more and have a conversation with healthcare providers that they'll never get in litigation. And I can't begin to tell you the benefit of that. It's also an opportunity when you have good plaintiffs and they go through the process is, by necessity adversarial. And I can't tell you the kind of beat down feeling that they get when they've had everything from their Facebook page to everything they've ever done scrutinized by a room full of lawyers. And to avoid that and to resolve these cases, and I do think they occur at a discount, but I don't think it's a way that penalizes the plaintiff. I think it's a way that recognizes kind of the time value of money. You're cutting 3 years off. It's a fair settlement, and it allows everybody to move forward. It's better for the system. So at least from my perspective and what we've done so far, I think, and you'll actually hear from one of my clients later today, who I think is a real success story in a number of ways, that it's a process that if we can get people to buy into it, plaintiffs' bar included, it's a good process. It'll never, there'll always be lawsuits because we're never all going to agree, but I think it's a good part of it.
That's great. So starting with you then, your approach as an advocate, you know, as a counsel at law, is it different when you are in the candor kind of process versus a regular case where you filed a lawsuit and you're moving forward in sort of the traditional way? How does that change in terms of perhaps maybe how you work with your clients?
You know, I'd say the primary difference is when you're in litigation, I frequently counsel my clients, you're not going to get to know what you want to know. It's peer review protected. There's some other privilege that protects it. They're here to defend it. They're not here to answer your questions. And so it's all about getting your client in a mindset of a system that is adversarial, and understanding that if I get you $1 million tomorrow, you're still going to feel crappy at the end of this day because that's how this system is set up. Right. When we go into candor, typically the conversation I have with my clients in advance of that, it's very different. What do you want to know? What is important to you about this process? And a lot of the clients say, I want to know why it happened. I want to know what they did that it doesn't happen again. And it's information, and I tell them all the time, this is your opportunity because you won't get to know that in litigation. And I think that's the biggest difference.
Great. How about from you guys? Is your approach at all different, you know, when, you know, it's one of the candor cases that fits within this versus kind of the normal, regular way you would approach one of these sort of events?
Well, I guess from my perspective, it really depends on how I'm hired in a case. So I have some clients who I have worked with for years and years who I'm like Great River, where I might be called upon to help them investigate a case, try to get an expert to review the case, try to find out was the care adequate, without being in litigation already. Sometimes I'm hired because the lawsuit's been filed and I'm contacted, and then we're adversarial from the start, just like Karen's talking about. But I have the luxury of at times with certain clients being asked to come in early where we can kind of chart the course as to whether or not this is a case we defend or whether this is a case that we do something else with. And hopefully we also advise them to talk to the patient and patient's family and open up a dialogue, because I think whether you're going to take the position that it's a defensible case and we're not going to pay or not, one of the keys to all of this is opening a dialogue with the patient so they're not in the dark completely. And I think that's a big piece of candor that shouldn't be overlooked, because it really is a big piece of what we see in litigation. So when we're in a candor type situation, or we've investigated for a client and we're urging them to go to candor or to make an early settlement to the case, and we didn't get involved at the time of litigation, it is a very different situation, because we're looking at it from the standpoint of how can we look at the system then, how care was provided, and was it good care, was it adequate? Some of the barriers to that are getting the medical records in a timely fashion, getting access to the physicians or other hospital personnel so we can understand their perspective and their point of view, and helping the client decide how to approach these issues when they do have the meet and greet with the patient. Yeah. Those are difficult situations, and sometimes one of the biggest barriers can be trying to get the records not only from your own institution but from other institutions, so you can really evaluate the care and what happened to the patient after they left our facility. So it's not always easy, but I think that there are real benefits to being able to do all of this early and make you're right, it can take years to litigate a case and quote unquote find the answer through the litigation. But if you've been doing this as we all have, you can get a pretty good idea of what's really going to happen at the end of the case in the first month or two.
Yeah. So how about from your end, changes in your practice or what you do or your approach to these harm events, if it comes in as kind of a candor piece versus the typical?
Yeah, I think I'd agree with Connie in terms of it just depends on the role for which we're hired. I don't have the depth of experience actually with candor per se. It's new law. I've certainly talked with a lot of clients who are considering it, evaluating it, but early claim evaluation has been going on for years. Lawyers have played a part of that, and we have for years. I've certainly seen, I think, a dramatic increase in claims being made, or at least claims known or identified early on and being investigated early on, long before there's ever litigation filed. And so to the extent we're involved in that early evaluation, I think it is a different role. In thinking about candor and talking about candor, you know, and this echoes some of what Connie alluded to, but, you know, the importance of that early workup, access to good information early on to make good decisions is obviously instrumental in the process being effective. I think that's where I see a small amount of a shift in terms of, as a defense lawyer, how that plays out if you're in a candor setting or an early claim resolution setting versus litigation, is that it really, I think the process demands a fair amount of information early on and that it be good information. I've certainly been involved in sort of on a periphery of looking at a particular claim, if you will, based on just kind of sparse bits of information, and I think it's very difficult to evaluate what to do with that type of a situation unless you have, you know, I don't want to say all information, but a significant amount of information early on, and that information is good information. You know, when you're dealing with a lawsuit, you have years to figure it out, if you will. I mean, not entirely figure it out, but you're continuing to gather information along a very long timeline where I see the candor process, not entirely unlike just early claims evaluation, as necessitating a more sort of fast and furious approach to getting the information and making sure it's good information, because you're making, you know, you're obviously premising your decisions on that information at the early state with a need for it to be complete, so that you're making the right, you know, the right judgment calls at that point in time.
Yeah. So what we see out in the field, somebody described it earlier today, which is a real critical one, where you know, healthcare is a team sport. It's a team of people who were involved in this particular harm event. The one we heard is the doc was ready to lean in and have the conversation, the hospital wasn't. But how about the flip side? You know, what do you do, or have you had cases where you've looked at it, you're pretty convinced from what you see and all the reviews you have, the care was bad, but you can't get the physician, you can't get your client to step up and be willing to do that? How do you, because that can get ugly. I mean, as you know, when you do that, how, again, as a counselor, how do you work with your clients to guide and convince them what you see as a really dark road, you know, down the way? What things have you done that work, you know, or don't work, you know, to work with that? And both of you guys, if you could share.
Well, I'll start. I look to somebody like Mike McCoy and say, come in here and help.
Yep.
They're your doctors.
Yeah.
And certainly that's a big help. I think peer-to-peer is better than lawyer to physician a lot of times. I mean, I think we can certainly tell them the dark side of what will happen. And I think, you know, though, as somebody mentioned over lunch, this is for protection of our physicians more than it is for the patient, but we can certainly give them the benefits of candor and why early resolution is in their best interest so they can avoid the data bank. I mean, usually what physicians are most afraid of is the data bank, the Board of Medicine, those kind of reporting problems. I don't know that I have too many physicians who that won't take our advice if we can give them a path that is not so punitive on them.
Great. Mike, how do you do that? Because this is, you know, a critical piece that's out there amongst, you know, physicians, particularly the most narcissistic of ours, who never, and those are the ones we deal with, right, who never can get to that point. Do you have any tricks you can share before we move into our other counselor about that? Because it's nice to hear you got pulled in, because I know a lot of organizations will take somebody trusted like you to help with that.
I'll let you know after next month when we have another one of these probably coming up, it sounds like. I just think having a relationship so that the providers trust you, and if you've been involved in the process and they know that you have their best interest in mind, to sit down with them and just sort of talk and say, hey, I really think this would be a candor case. You should consider it, and here's the reasons why. So far, we've only had one provider that's neglected to follow that. And so I just think a lot of that is just them trusting you and having that relationship. Otherwise, without that, I'm not sure you're going to have a lot of influence any more than Connie would.
Yeah.
So.
Do you ever pull in sort of just culture principles when it comes into this? Because if we've had a doc who's kind of trapped in the system, and it was a human error versus reckless behavior, we will really love them through the case and even bring that to the licensing board. We did that in Illinois all the time, and they never got sanctioned. When we bring forward, hey, this to err is human, this is a simple human mistake, our system was designed and really contributed to this. Do you ever use that? Have you taken advantage of that at all?
Yeah, absolutely. And
Cool.
and I think I'd point out the majority of the times the cases we've had have been process issues, have been system issues. And in the old system, it's pretty much, it's the doctor, it's the nurse. And it may have been a process, but that's who ends up sitting in front of someone answering questions. And to sit down with them and say, listen, we realize this was a system issue. You're part of the system, so you're part of it, but this was a lot of a system issue, and we can address this as a system. And that's, I think it's kind of, it helps them to know, hey, it wasn't just me, and even though they're the one that's sort of in the driver's seat about some of those things.
Great, thank you. How about you? Have you had to do any special things to bring a client along to what you're seeing?
I mean, it makes me think of a couple points. I guess one, I don't know that I have the answer to solving that issue, but I certainly think that the selection of the individual to review the case can be significant in that regard. In other words, if you have an expert review at an early stage, I think it's important that if there is a physician involved, that physician, I'd give them a heads up, this is who's going to look at the case. I think if you have an expert witness who the provider trusts or respects, they're going to value that review in a heightened way, in a more meaningful way. So if they're not trusting you as your lawyer in terms of your own evaluation, they may well trust a peer evaluation. And so I think involving the physicians with either the selection of the expert, but at least discussing, okay, this is who we're sending the case to. They're going to take a look at it. They're going to get back to us. Oftentimes they're waiting for that. What did Dr. So-and-so say? What do they think? And they put a lot of stock on that, whether it's good or bad. And so I think having a trusted expert at the early review is important. The other point it made me think about, your question, is just something that, in terms of the questions that we've fielded thus far on candor, that's one of, I would say, probably the most common questions I've had is, what if you have a situation where you have an institution and an employed physician, and that employed physician does not want to take part in the process, yet the institution does? My role in those discussions has really started down the lines of, do we need to think about some contractual provisions? Do we need to look at employment agreements? Do we need to build in, and I know this is supposed to be a voluntary process, and I think probably those who know more about candor implementation than I do would see that as an important part of the process. But I've certainly had clients who have brought that up about, do we need to be discussing that with our employed physicians, recognizing there could be an impasse at some point on this issue of, do we or don't we participate, and what do you do, and do you have some contractual provisions to dictate how that goes?
Well, some CMOs, Mike, you can imagine, they just say, look, we're going to go have a conversation, tell them what happened, we'd like you to join us. It's up for you if you don't want to be there. And they get nervous. And that's why they say, you know what, I better be there for the conversation, because they don't want to miss it. So Karen, I got to bring this up. Rick Boothman mentioned it at another meeting, and it's the issue around the fees that the plaintiff gets. If you've got an organization coming in and they're clearly admitting liability, and none of that work is going to need to be done, is there any movement within the plaintiff's bar, plaintiff's attorneys, that, hey, we'll do a little different fee versus, and I know that's a hard question and unfair, but I just want to get it out because sometimes it does come up.
I can't speak to the plaintiff's bar because I think it's interesting for me, when I was sitting here and listening to folks this morning talk about how interested the plaintiff's bar was in this, boy, that's not been my experience. My experience has been a little more of pushback, like, oh, you're doing this kind of thing. I can tell you what we do. I mean, we enter into our standard contract with the client because you don't know that candor's going to work, right? I mean, you could get there and then the financially speaking, it might not work. And then you have to move forward. What I can tell you in the cases that we've resolved through Candor, we have not taken our full fee. And it's more of a process where you're sitting in and the client has expectations and the hospital has expectations, and you know in your head kind of how this works. And again, I come back to the time value of money, but I look at that even from my end in terms of, okay, this was 4 months. I did have 2 reviews, I did this is what I've done, but it's way less than the gazillion hours I'm gonna put in to go try a case for a week. So we always look at it, and I always have in my back pocket to work with my clients on the fee, and they're always really appreciative of your willingness to do that, because I think you have to get everybody to buy in that it's about making the situation right. And that includes the plaintiff's bar. Because the only way really sometimes to do that is to change your fee structure a little bit so that there is a little bit more in the client's pocket. And it seems like, okay, this really did seem fair to me. So that's at least been my approach in the 4 that we've done. It will be my approach going forward. I mean, I think every case is kind of individual, but I anticipate that, it does fall below. The other problem is that we still, which unless it's really an unusual circumstance, we still are at a third where I think we heard 40 and 50%, because we feel like that's, we do have 40% cases, but it's cases where we carry really, really big expenses for a long time, and then that's a small firm putting out hundreds of thousands of dollars. So we will increase our fee to 40%. I've never taken a 50%. I mean, I just can't even imagine the conversation with your client when you're taking half of what's coming in. So I think culturally speaking, there is that question too, is if you can get people to look at the benefit of taking a little less to make the system a little better.
Yeah, boy, great to hear you say that. I applaud you for that. Mark, it gets back to your comment in the other session about how inefficient this can be, prior to Candor. And if you think of Candor and the total amount of money that goes into resolving this, way more goes to the patient and family than in the old traditional way. And we saw that as well. We did hundreds of these cases at U of I over the course of that 8 years, and we saw the same thing. A much bigger percentage. It's much more efficient in terms of moving forward to do that. So where do you think the rest of the plaintiffs' attorneys are in this? I mean, are you getting pissed? Are you getting pushback from people saying, Karen, what the heck are you doing? Or
you hear it a little bit, sure. I mean, I think, I've talked to some other plaintiffs' attorneys about it and said, I think you can't, it's that whole thing. I've got a 21-year-old daughter, and so when we talk about things, sometimes I'm like, it's not enough to talk about it. Sometimes you actually have to do it. So if you say you do this because you want the system to be better and you want patients to get better care, then how do you step back because of finances from a system like this? Because it does make it better. My Candor clients are way happier than clients I've gotten millions and millions of dollars for, because they got answers that those other clients never got. All we did was fight and battle and put up our experts and litigate for 3 years and come up with a settlement. These folks, you kind of build in things to the settlement. We've built in some, Mike will tell you, we've built some crazy things into our terms of settlement that have been very directed at the very personal needs of the clients, and so they're happier. Even though it's less money, they're happier. And that's the part where I think at some point, and I do think the plaintiff's bar will eventually buy in, but there's a big trust thing too, right? 'Cause you can't write anything down. You have to get into the system, I think. You got to give it a chance before you understand that it really does work.
That's great. So any 3 of you, or all of you, I'd love to get the input from this, because you just mentioned it. There was, AHRQ put out a recent white paper around this, and Carol Hemmelgarn, who's a patient advocate, wrote about the non-financial components of this. Can you guys comment on some of the innovative non-financial resolution pieces? Because I was just on the phone with a group in California. They had 10 insurers there all talking about this. And I said, hey, I'm going to be with this panel. They want me to ask this question can you share some of the innovative things you've done on the non-financial resolution side?
Well,
Just love to hear that.
So one was a patient whose child had a stillbirth after a bad deal. Any way you called it, it was a bad deal. And the patients, Karen's clients, suggested that there's all these pictures of the babies that were born at the hospital on the wall, but there's nothing in recognition of the babies that weren't born because they were stillborn. And they wanted a garden for a memory garden of sorts. That was obviously a very moving situation. Actually, I had one not all that dissimilar a few years before that, where some folks put the money that they got, I mean, it was actually a financial transaction, but the whole point was they were going to create a dog park in memory of a deceased child, and commemorated it as such, and wanted the money to pass through directly to a charitable organization, which was a nice thing. We've also had a lot of service provisions, so counseling for a year, or the provision of a lab draws, or a family physician, or an endocrinologist who they couldn't get in to see well, or were having difficulty, somebody who had some significant medical issues and was really having difficulty getting through the barriers of the medical system to get the right providers. So just the assistance of Great River to help them maneuver through that system and say, here's a doctor, this person's going to take care of you, they're going to see you on a monthly basis, and one, getting it established, and two, I think we paid for it for a year or two, and then maybe the patient would be on their own after that, but at least they'd have established care that they were struggling with getting. So those are the things that we've seen.
Stacy, have you had any others besides unique,
Similar to that, those are some very innovative thoughts that Connie brought up there. But similar type things. I mean, usually at the forefront is the monetary piece, but on occasion we'll add some additional terms. I know there have been some requests for certain policies. I think there's a perception that policies, what's in writing, sometimes dictates, and it does dictate, and from the perception of patients, they like to know, has there been a change? Has there been something in change, and can I have some verification that in fact has occurred? The other thing that has come up, and I know has been a desired piece of some resolutions, is what's very, I think, somewhat inherent in the candor process, which is just an acknowledgement or an apology, or if not an apology, then like I say, an acknowledgement piece. So no, I think there's certainly room to add that, and obviously you've had success, Connie.
That's great.
We've also put them on the patient advocacy boards,
Yeah,
which
actually,
is
one of my clients is on a patient advocacy board at Great River.
Yep. Yeah, no, that's great. We had, there's a very big case we had, it made it in the press, of what's called the Malizo-Balog family, where a 39-year-old came in for a GI procedure under sedation, and we did a massive overdose, failed to rescue, and she ended up brain dead in our ICU. Horrible. CEO, major corporation, Northwest Indiana. This was a very expensive case. She had 2 little kids. Part of the resolution there, kind of fitting to what you did, is we, and this is what I want to ask you about, the timing of when you talk to families about it. They didn't want to talk about any of the non-financial stuff until long after they got over it, and even the financial resolution part. They wanted to make sure the kids were taken care of and all that. But we reached out a year later and invited them to be members of our Patient Safety Review Board, the group that reviewed all serious safety events in the organization as the conscience of the community. And it was pretty amazing to get them involved. The other thing we did, because this was a moderate sedation case, and it was in a hesitancy on the part of the nurses to stop the line, kind of like we learn in Team Steps, we put everybody in the organization through the sedation training, and the key word that they would say if the nurse felt too much sedation was being given was, you keep going up the ladder, I have a concern, I'm uncomfortable, it's unsafe. The last thing they would say is, I'm asking you to stop. Michelle told me to tell you to stop. And Michelle's the woman who died. And we told the family that, who loves it, because in the organization, you say that, everybody starts paying attention. So it's sort of the legacy of saying, we really do take you seriously, and we're going to change and put it in this piece. So there's these different, any other out there? Mark, have you seen any, or Alan, have you seen any kind of unique non-financial, or even Mike, other non-financial stuff? Because I think in a forum like this, it's important to realize, like Karen said, it's not all about the money. You know, it's about taking it seriously and changing. But any other innovative things that you can share, you guys know of, you could share with the group as well.
So we have a lot of situations in the reimbursement agreement. I mean, we had a situation where the patient received irradiation and she was nursing. It was clearly in the notes. Probably wasn't, a big dollar case, but we actually paid breast milk. I mean, which just seems like you wouldn't think. It's kind of, but at the time, that was the critical element, and it was thanks to somebody like you, we were able to say, gee, what is it really that's going to be the critical thing? And if maybe there was somebody who was a little callous, said, well, all you got to do is pump and you'll be back in 3 months. That was devastating to the mother. So I mean, there's probably everybody's got a story like that.
So Tim, I think the kind of remarkable thing for me is after being in the tort system for 40 years and then coming over to COPIC as general counsel, in the 3 R's program, where there's immediate discussion with the patient, much of it is either non-monetary or very low monetary, like, would you just find somebody that could help me walk my dogs or take care of this or take care of that? So I only say that because the remarkable difference is after handling hundreds of cases in the tort system, probably, I'd say less than 1% did we get a request that something be done other than monetary. And so I think what I mean by that is a year or 2 has now gone by. It's wended its way through the court system. Kind of all those things that were opportunities to help this patient are now gone, and the entire focus is on money at this point. And I don't mean that as a criticism of anybody. It's just a lot of lost opportunities and is representative of how the tort system doesn't really work well.
Yeah. So getting to that financial piece, how comfortable or challenging it can be, and have you had cases that you had to take to trial to just litigate on damages? Where you own it. You're not going to try to defend the care because it's so bad. Have you had cases where you've just had to litigate on damages? And, well, let me just ask that question, because then I have a follow-up related to candor and that piece.
So I'll start, Stacy. I guess I have, although I always try to save something that I can argue on liability, which can be precious, A, difficult, and B, sometimes backfire.
Yep.
But certainly I think we may settle them before we get to the courthouse, but we've certainly litigated the heck out of a lot of cases where really all we're fighting about is damages, because we know there's a sponge left, or there's, some of that stuff is just, of course it's a liability case. It's just a question of where are we gonna.
So have you had the opportunity in those cases to let the jury hear how empathic and sorry the clinicians are that this has happened? Where we own it, they're trying to screw the organization. We've done the right thing. We've reached out. We think is the principled way. We think we've made a really good offer. We learned from it. We're sorry this happened. We want to move forward. Have you ever gotten into that kind of conversation?
Not in front of a jury. I think we've resolved all those cases before.
Okay.
We've been ready for that if
Okay.
we couldn't resolve them, and I know some plaintiffs' lawyers now that I can see that happening, but I don't know, you, Stacey, have you
Stacey, how
tried
about your end?
a damage only?
I can't think of one where we've tried a case purely on damages. As you said, I can think of instances where causation of the damages has been in play, or there has been some aspect of a liability defense, but I'm hard-pressed to think of a case that's actually made it into the courtroom just on damages.
Okay. So, and then Karen, I'll have you comment on this. So in 2005, Illinois passed tort reform that included the apology protections. But it was very weird how it was set up. It was the expression of empathy or apology could not be used for any reason so long as it was given within 72 hours of the harm event or when you knew it. Beyond that, it could come in. And so with our general counsel at the U of I, we made a decision that if we really knew that our care was really bad, and there's no way that we were going to defend on liability, we made sure we apologized after 72 hours to make sure we could get it before the jury.
Yeah.
Because the mock trials show if you get that before the jury, the awards are way less. Versus the jury's wondering, why am I not hearing that the doctor said anything empathic and the rest of it? And the ironic part, Karen, is the plaintiff's attorneys are the ones who really push for that law in Illinois because it was for any reason. And so that you could not even use it to convince the jury that you had empathic people involved in that. So I don't know how you feel about, you know, that sort of stuff in the apology laws. I know it's great to have when you're expressing empathy and you don't want that to come against you when you're not admitting liability, but in general, how have you seen that whole landscape overall?
You know, I think our law is a little broader. I think you don't get to use it at all in trial, or at least it's always the subject of a motion in limine, and typically a motion by myself as well to say it doesn't matter if you it has nothing to do with the standard of care. So if it doesn't come in for me as a sort of that, oh, it's culpable, it's culpability, then it sure doesn't come into them like, hey, I'm a nice guy. I mean,
That's right.
So I think that's so for the plaintiffs folks, I'm not sure what they were doing over in Illinois, but I sure would have filed a motion in limine on that question.
And they would. I mean,
Yeah.
they did not want that to get in, and at the end of the day, they didn't need it because they had enough on the
And I'm not
liability
really sure where it gets you, because at least in my experience in talking with juries afterwards, I don't think that they ever really take the apology as an admission. I really haven't had the experience where jurors equate those two.
Yeah, well, I mean, I'm going a little bit further, which is, because what they have talked to mock juries is, if they've heard an empathic response from the doctor,
Yeah.
they feel better about the doctor.
Yep.
You know, not that
Yeah.
it's admission liability. So I just toss that out to be provocative because, you know, we were in that weird
I think
position.
that's true. I think if
And-
you get that in, this is why I fight it. I think if you
And
do
I
get it in,
pushed like heck to get it in.
Exactly.
Well, and
I
see,
do
so
think-
there's the issue,
I
right?
absolutely think it softens juries and it doesn't
Yeah.
help plaintiffs.
Right.
I agree with that 100%.
Yeah. So I've always struggled with the apology laws for that reason. I think they're great when you don't want just that, hey, I'm so sorry this happened to you, somehow or another be used to get in there when they weren't in fact admitting liability when they went in to do that. Horror stories from you guys in terms of communication that happened and you're like, oh boy, they rang that bell and I really wish they hadn't done that. Have you had any, like our most famous one is the docs will go in and say, I am so sorry this happened to you, but don't you worry about it. The hospital is going to take care of everything. And the hospital's not very happy, you know, when they hear that. University of Chicago is a very famous, huge case where a doc did that. But any horror stories from your standpoint of, oh my gosh, I wish they'd talked to somebody first before they went in and had that first conversation?
I can think of some facts in dispute where plaintiffs have attributed statements to medical providers ringing in the tones that you're talking about there in terms of alleged statements that a physician had said that, perhaps a physician said the outcome wasn't what we wanted or things didn't go quite as planned, and then kind of through the course of the litigation it becomes something different than that, which was more akin to a statement of fault. I can think of a letter at one point in time several years ago that was sent out on behalf of a medical institution that was, I think, attempting to fall under the Iowa's apology law, but didn't quite get there, and went a little further in terms of incorporating admissions of fault and then just a whole litany of changes that were going to be made, some of which were actually made and some of which were never actually made by the time of trial, and really having a pretty significant dispute over whether or not that letter would be admissible under, at that time, what was just the Iowa's apology statute. So,
How about any bells that got rung where you wish they weren't rung?
Well, you know, I mentioned this earlier today to Karen. I had a case not too long ago. Somebody was talking earlier about missed, not errors that amounted to anything. And I had a hospital that went out of its way to tell a patient about a medication error that caused a mother's blood pressure, mother that was in labor, caused her pulse and blood pressure to increase. They were trying to affect the baby. It didn't affect the baby, but they gave the wrong, I think they were supposed to give, you guys all know this, epinephrine, and they gave ephedrine or vice
The other way.
versa. Okay,
Yeah, yeah.
So, but ultimately, it didn't raise the baby's heart rate, and so they ended up having to do a C-section. So even though they hit it with a sledgehammer instead of a hammer, it didn't affect the baby. They had to go ahead and do a C-section. The baby delivered. The baby was fine. The next day, the hospital agonized over this and brought in the nurse who'd made the medication error and her supervisor and the hospital administrator, all to come in with this very organized apology about how they'd made this med error. And it ended up in a lawsuit when there was no damages from it. I mean, and I, frankly thought the apology there, it was too trumped up. It wasn't done immediately, and then it wasn't done immediately because the poor woman had to go have a C-section, but the timing and the whole process of it was so off that these people thought there was really something to it. And in fact, there wasn't, and it did happen, but it just didn't amount to anything. But they gave it so much fanfare that a notorious plaintiff's lawyer took the case.
Karen? That would be Karen?
Not Karen, not Karen at all. Took the case and litigated it, and we just kept saying, that you just don't even have a case here. There's nothing, nobody was hurt by this.
Yeah.
And, we litigated it for years. And so you can do wrong by overdoing an apology or making a mountain out of a molehill. They were trying to do their best to acknowledge a medication error, but they were dealing with naive people and then dumb lawyers. So.
What Bruce and I try to teach is the trigger for the communication is actually very early on the assessment of harm. If there's not harm, then we usually don't go in there and talk about mistakes we've made. I mean, just in general. Now,
Yeah.
that's one position. And it really helped us a lot over the 8 years, is there harm? If there's not harm, we're not going to tell them about all mistakes because as Bruce, as you know, is a big pharmacy guru, if you really look in charts, and this isn't to scare the non-clinical people in the room, every patient in every hospital in the country has a medication error every day. Usually doesn't hurt them though. It's a 2-hour delay in getting medication that didn't make a difference. It's a little bit different of a dose than they should have gotten. We would be spending our whole day talking to patients and families about all the mistakes we made if we went down that pathway. So there will be times though, I believe when mistakes are made, if the family sees it, that it's good to get in there, have the conversation, but also explain why it didn't hurt them.
Yeah.
To begin to do that.
Yeah.
How about, Karen, from your standpoint, the things where it's a gift given to you because of they weren't mindful, they didn't talk to these guys, or they didn't talk to Mike before they went in there and had the conversation.
Well, the first thing I'd say is I've never gotten that letter that Stacy just, but you feel free to send that to me anytime you would like to. I don't know. I don't ever get letters like that.
Well, this is transparency, so she kind of owes it to you as part of the conference.
I think so.
Yeah.
We have had, what I have seen, and I don't know if this, I've got a couple cases right now that in the record, a treater has given me a gift where, and you never used to see it, but in some ways I think it's it's a multi-provider situation and it's a really bad outcome, and the provider whose fault it's not is like, oh, I am not going down with this ship. And they put a note in there that is the trigger, and you're like, wow, that's unusual. And I see that more now where I think if this process, if you initiate this process as an institution or as an insurance company and you get your physicians to buy into it, I don't think that, not that I'm encouraging it doesn't happen, it makes my job easier when it does happen, but I think you'd see less of that because I do think there's this every man and woman for themselves, and it was a situation where this particular provider was called too late to effectuate the outcome, and it ended up in being a very bad result.
Yeah.
And I've seen that a couple times, and I think that's kind of a culture that institutions should try to get away from.
Sure.
I can tell you, the biggest boogeyman to the clients is they're not being told what's going on. And I've had cases that I've pursued, and we had a case once, literally, this was probably 10, 12 years ago, where what the family really wanted was their medical bills wiped out, an apology, and there was a third thing. And the physician who was to give the apology refused, would not give it. It was a multi-million-dollar resolution 2 years later. And I thought, God, your pride and your ego is so great, and you're wrong. You're flat wrong on the medicine, and you won't provide the apology. And it was like it was below him to do it.
And Bruce, I highly recommend this book to everybody here. It's the one Bruce mentioned. It's written by John Banja, who is a psychologist who has studied this forever, and it's called Medical Error and Medical Narcissism. That probably is a situation where he's so pathologic, he has a complete inability to do that. And those are the people we try to balance out with good communicators. You know, when Bruce and I go into organizations, one of our jobs is to find out, do you have these people in your organization? And why it's so important on the patient safety side, you guys may have heard this, is you're familiar with Jerry Hickson's data out of Vanderbilt? So 8% of physicians generate 50% of non-solicited patient complaints and an equal disproportionate number of risk management dollars. And it's been proven over and over and over in all organizations. But here's the part, because it fits into the improvement in the safety piece. He just published in JAMA, if you track those physicians who generate the complaints and the risk management dollars, we can now show definitively for the first time their patients have way more surgical complications when they're surgeons. And so part of the role you guys can play, if you can bring them around to see some of these issues, you can have not only a big impact on the litigation side, but on the safety side. Yeah. And we know it's that group. You know, I mean, they've studied it, they've looked at it, they know it's that group of folks that are there.
You can, from the plaintiff's perspective, I would say, fairly identify physicians, whether the case settles, you win or lose a trial, that you will see again.
Yeah.
And it's more based on personality and ability to empathize with their patients. For a long time, my partner and I, we would lecture over at the University of Iowa Medical School. And let me tell you, that's a hostile crowd when you walk in as a plaintiff's lawyer. I mean, it is a hostile situation.
Just a lawyer. When
You
I
know?
walk into those places as a lawyer and a physician, they're hostile.
Oh man, it's brutal. But when you talk to them and say, I'm not your enemy. I have so many friends that are physicians. What I'm here to tell you is talk to your patients, you know, and God, keep your chart for God's sakes, and you know, treat them. Don't leave them in the dark. Don't be dismissive of their concerns, because those are the things that piss patients off. Sure. And 9 times out of 10, it's what starts the process, is because you've been dismissive or you've talked to them like they're 6 years old and a moron. Like have a conversation with them and speak to them in language they can understand. Yeah. You avoid, and that's why I like the candor process, is it gives people a chance to ask questions and get answers.
Sure. Well, and not only did they piss patients off, what we found is, and I advised our general counsel and other people, you do not want to take these 2 physician defendants to trial. Mm-hmm. They are the one construct communicators. No, we knew that. I mean, because we had tested all of them. We said, you are really, and you better try to prep them and do all that, and they weren't able to do that very well. So not only did they piss off the patient, they pissed off the jury.
Yep.
Oh, sure.
And it was so predictable, which is, again, we see the value in this communication assessment. I would have anybody have them do this assessment so I would know, if I was a lawyer working with them, what am I kind of dealing with in terms of being able to do that. Mm-hmm. So where do you see candor going? I'll have each of you do this now towards the end. Where do you see it going? And do you see any need to change the law? In other words, have you seen anything, experienced anything, hey, if we were going to tweak it to make it better, what would it be? And we'll start down there, with you, Stacy, and have you come this way and have you guys reflect on that and chat about that.
Well, I think I see candor expanding. I think one of the challenges that I see now under Iowa law is just synthesizing the existing laws that we have into processes that places can implement. Iowa is unique in that we now have candor law, but Iowa has been, in a lot of respects, progressive with laws in other areas like peer review. We have a strong M&M statute, morbidity and mortality statute that affixes certain protections to communications. We, of course, have the apology statute that we've talked about. And so I think there is certainly the legislative framework here for these types of discussions. I think, like I said earlier, it's just going to take some time for entities to develop the right processes to be able to carry these out and to be able to, again, kind of take steps in Iowa in a way that's consistent with the laws that are now on the books, and make sure that they're in some ways compatible. And so I think, as kind of Karen alluded to earlier, sometimes you need to try it and kind of start working through the process to see the different bumps. As far as any changes to the litigation or to the existing statute, I think actually the amendment on the definition to include injury and kind of removing some of the adjectives that were in there is a helpful step, because I know there was a lot of uncertainty about what events would fall under this process, and people hesitant to even take a chance that maybe they'd initiate the process and then this not be a qualifying event. And so I think that was one thing that was a good change in terms of in an effort to expand it. So I know it's getting a lot of discussion, I can say that much. I think right now it's almost like I said earlier, there's just a lot of questions coming in, but I think that's indicative of organizations' willingness to consider this. So.
Great, thank you.
Well, so I agree with everything Stacy said. I think one of our biggest challenges is going to be clients working with their insurers to figure out how this is going to work and how to deal with those situations that cross multiple insurers. We talked about that in our breakout session. I don't know if it was a subject in here, but that's, there's not the University of Iowa and Great River, and there's a few other places in Iowa that are very much almost 100% one entity, but most places aren't. And so, you have to have the coordination between the various providers, the hospital and the physicians, and there may be more than one physician group all in the mix, and then you may be dealing with multiple insurers. And I think from the insurer's standpoint, they're operating usually from the standpoint of, we need a claim, and we've got to get that mindset, especially since the candor process, it has to be initiated under the current law. It has to be initiated by the entity or the physician. And you call your insurance company, who is very claims oriented. They're going to say, well, why would you do that? There's no claim. Why would you go start a process like this? So there has to be a coming together on how to do that and what situations are the right situations to do that. And I think we really have to work hand in glove between the entities and physicians and the insurers to come up with a process that makes sense. And I guess the last piece of that is in terms of whether the law needs any changing. I'm not sure that, I know Karen probably has, and I know I have a client that tried to call today while Karen was in the car with me, that had a patient that wanted to initiate a candor process. And they said, we want to invoke candor. And it's like, well, theoretically, they can't invoke candor. That's not what the law provides. Should it? I don't
Because in
know.
Washington law, they can.
Yeah.
So there's, different states have toyed around. That's why it's getting a lot of data from lessons learned, and what you guys are sharing here is so critical to share across. Thank you.
I would echo with what these guys have said. The thing that I would add is I think meetings like this are really helpful. And I think getting a meeting, this is more provider-driven. You have a lot of, you have some defense counsel, you have hospitals, you have insurers here. It's getting the plaintiff's bar involved. And in some ways, not just the meetings like this, but even, if various institutions, different hospital settings can say, hey, we're going to do this, and we're going to bring in a plaintiff's lawyer, and we're going to bring in someone who's done this before, and we're going to sit down with our staff and talk about, I think a lot of it is people don't understand the system, and so they're not participating in it. And it's an interesting conversation when you sit down. When I first talked to Dr. McCoy about it, and he's like, what do you think? And I said, I think it's a good idea. I think this, it won't work for everyone, But to the extent that it does work, it takes burden out of the system, right? You're taking claims that aren't going through the court system that's already overwhelmed right now. And you're identifying people that you're helping financially, emotionally. You're taking that burden off of your provider. I mean, nobody wants the surgeon that's worried about his deposition tomorrow doing their knee surgery
Right.
the night before. I mean, nobody wants that, right? And so you're addressing things that the legal system does not address. But I think the insurers and the hospitals and the institutions can do more by doing things like this so that their staff starts to understand. If you always view the other side as the enemy, you don't go anywhere. It's like walking into the room full of med students who look like if they could throw darts at me, they would.
Well,
you know?
because you had the horns up.
I
and all that,
know.
and they saw that when you
but
walked in the room.
And by the end, you're talking to them, and they're like, "Wow, that's the best piece of advice I've gotten all year." And it's just common sense of, this is what you approach your patients. You're going to be 10 times less likely than the guy sitting next to you if you do these little things for your patients. So, I mean, I think it's getting people to buy into how do we make the system better versus how do I win more cases, how does she win more cases, how do you save more money. We all have to buy into making the system better.
Great, thank you. Any other questions from the audience for this esteemed panel? We have one up there. I'll repeat it after you say it.
How do you counsel your providers on the actual apology for Stacey and Connie? And then Karen, what's the apology that your clients want? And I guess my question is focused on the typical not apology we give, which is, I'm sorry you didn't receive the care you expected. It's not really an apology at all. So what are you telling them? And then Karen, what do your clients actually want to hear?
Well, I suppose it really depends on when in the process you're talking. I mean, have we recognized in fact that we've made an error? Or are we apologizing for a bad outcome that we have yet to investigate whether or not there is an error? I mean, I think those are two different scenarios. I mean, I think if you've made an error and you know that the error has been made, I think you have to. And you're ready to say, I'm ready to embrace candor. Let's go through it. I think the best thing to do is to get yourself into a candor situation. So your first conversation is, we want to share information with you. We want to get with you as soon as we possibly can. We are in the process of gathering information. Here's the person who's your conduit for information. We're not going to hold anything back. Let's sit down and talk. And at that, if they agree and are in agreement with regard to the candor process, I think you make an explicit apology in that candor process and say, we did you wrong. Here's how we're going to make sure it doesn't happen again. Here's what happened. I mean, I think that's what the whole candor process is about. If you don't know yet whether you've made a mistake, it's real hard to figure out how to apologize for that, isn't it? And you really are protective of whether or not you're going to say something that you're going to regret later,
I just absolutely agree with what Connie's saying. I think you need to know the purpose for which you're making the statement. And I think that goes back to what I was talking about in terms of the multiple laws on the books now. I think as defense lawyers prior to candor, we're so programmed, I think to a certain extent, to operate under the apology statute. And, the thought is, plan for the worst, hope for the best kind of thing, structure your statement if you're in the context of anticipating litigation. But as Connie said, if you're in a candor situation and you're going all in and you think that apology is instrumental to getting a case resolved and that's the goal, it may be different. So I think understanding the purpose is key, as you say.
And Jessica, what I hear from my clients is first recognition, right? So I would say that the little film where the doctor comes in to do the apology, that's almost the worst case scenario, honestly, because my immediate response to it is she's being dishonest. She walked in and it was like, well, let me try and slide it by this way, and if they don't ask any questions, then I'm all done. It's if you've identified it, come in, say, hey, we've identified this issue. You don't necessarily have to take responsibility, right, for it in that moment. This is what we're going to do to determine how and why this happened, and be upfront with them and be honest with them. Return their phone calls. I mean, I can't tell you how many times I've had clients say, well, they told me they were going to look into this, and I've called 4 times, and no one will tell me what's going on. That's the worst case scenario, because what you're building is mistrust. and them thinking something really bad happened and now they're sweeping it under the rug. I mean, that's the society we live in, right? So it's one, recognizing it, two, saying you're going to do something about it, and three, following through. And then if you really do have a situation, you've built a situation where that client is more interested in resolving things with you than the client who felt like, you blew me off, you lied to me, why should I trust you in this process? So I think that's the biggest part of it, is them feeling like, okay, you're not selling me, the Brooklyn Bridge. You're being honest with me. I think that's huge to most of the people that I speak with.
Yeah. And Bruce mentioned that in the other panel. It's three things. And when we do the training, this is a test question. They want three things. They want honest, truthful information about what happened. They want their emotions validated. You may not think it's a big deal. If they think it's a big deal, it's a big deal. So there has to be this training around authentic validation of their emotions. And sometimes that means an apology, and sometimes it's just validation of the emotions because you didn't make any mistakes, but it's there. And the final, Karen nailed it, which is you got to have follow-up. And if you tell them you're going to be back in a day or two, you better be back in a day or two. That really is what we train. The trickiest part, which is why we do the communication assessment, is some people have a really hard time being authentic in these conversations because that's what they want, authenticity. They want a connection. It's the empathy versus sympathy piece that we saw in the video. And I wanted to remind all you guys, I've made Michelle and Kate all the videos available to you, how you can get all of them. They're yours to use in your training and all the rest of that stuff. Any other final question or what have you? Otherwise, Kate does.
Cut you guys off. I
Yep.
just want to thank the panel for your time. Thank you guys very much for coming.
All right.